Okay, I hope you guys are sitting down right now because the US Supreme Court just handed a massive slam in the door to AI bros trying to claim that machines can be artists. They've officially declined to hear the dispute over whether AI generated images can be copyrighted, and honestly, it is about time someone in a robe, some judge, some official acknowledged that prompting does not equal being an artist, and it does not equal human authorship. Today, we're going to talk about this and why I believe that this is like a massive win, and why AI bros are probably having a meltdown somewhere, but probably on Twitter. So it starts here over on Reuters. It says the US Supreme Court declines to hear dispute over copyright for AI generated material. And I'll link it below for you guys. But I feel we have to talk about why this has been happening. Because why would the Supreme Court do something rare and actually listen to common sense? So they declined to hear the appeal from Stephen Thaler. And if you guys don't know who he is, he's the guy that has been trying to force the government to recognize his creativity machine as a legal author. And by refusing to hear his case, the Supreme Court just put a massive, ironclad absolutely not on the idea that a piece of software can own copyright. So this is the guy. He is obsessed with AI. So this 73-year-old inventor has this thing called the Device for Autonomous Bootstrapping of Unified Sentience, or DIBUS for short. He's demonstrated that an impressive number of achievements, like it's replicated the ability to dogs to detect prostate cancer from urine samples, achieving accuracy over 95%. So he believes that his thing, DIBUS, has sensory experiences and even dreams. And because of this, he thinks that his thing is creative. But he is trying to get a copyright registration since 2018, covering a recent entrance in paradise, a visual work that he said his AI technology DIBUS created. So I'm going to show you guys what that is. It's this thing. The thing is okay, a lot of people remember when AI was just first coming out, and a lot of it was just imagination. Do you know what I mean? Where it was more your brain filling in what was not there and what was there. It was more you're using your imagination to make the art than just generating and prompting tags until something came out, right? But it was crappy. It's different now. But this is something on old train tracks, overgrown stuff here. You know what I mean? Now, the thing is that he openly admits that he didn't make it, that his AI made it autonomously. So the Copyright Office said no, the District Court said no, the Appeals Court said no, and now the Supreme Court has looked over the appeal appeals and said, we ain't even gonna do this. Because he tried after he got a rejection in 2022, and it said that, all creative works must have human authors to be eligible to receive copyright. And it's weird because, I'm not trying to get into politics, but even the president urged the Supreme Court not to hear the dude's appeal. So I don't know what that means, because he's already been AI forward. So I don't know what this means. But you know what it means? Long term, I think that this is a way to stop people from kind of spamming copyright registration. Because do you guys see how many AI bros basically generate? They're not generating one image. They're generating hundreds, sometimes thousands. That one guy, that Brandon guy with Theater de Spatial or whatever, that guy did 40,000. Coca-Cola did 70,000. It's. Can you imagine all of these being copyrighted individually? That would be crazy spam. That is so stupid. And his lawyers are kind of telling us that the sky is falling, and they're claiming it's going to do irreversible harm to AI development. Oh my God, please. What it actually does is protect human creators from being burdened and buried under the mountain of machine slop that would have definitely been used to squat on every possible idea known to man if it were allowed to be copyrighted. And I partially saw this thing where someone says, so if I write the prompt, am I not the author? And someone replied with, prompts alone do not confer copyrightability. The report concludes that guiding AI output using prompts does not meet the threshold of creativity required for copyright protection, taking the position that prompts function as instructions that convey unprotectable ideas. Additionally, because AI models operate unpredictably, the United States Copyright Office takes the position that even detailed prompts or prompt engineering do not give the prompter sufficient creative control over the resulting output to claim authorship. So it's a win for American artists and Americans that are authors or music writers or whatever. But I also wanted to bring up another thing. There's this guy I follow named Ed Newton Rex. He has a lot of AI stuff. He's anti-AI like me. And he puts a lot of posts out there that I think, people should know about. And it says here, it looks like the UK government is gearing up to upend the copyright law in favor of AI companies legalizing the theft of their work. This is despite creatives' huge protests and despite the previous proposals being roundly rejected by the public. There are rumors it is considering introducing a commercial research exception for AI training, which would be disastrous. We talked about this in my last video where I talked about the issues going on with the UK. It would mean handing the life's work of British creatives to AI companies for free to train their models on. In the House of Lords today, the government minister refused to rule this out. To be clear, this would amount to legalizing theft. It would fly in the face of the public on what is fair and what it would mean to surrender of British creatives' work by the Labour government. It would mean the lobbying by big US tech firms has succeeded and the protests in the UK creatives have been ignored. People's work is not the government's to give away. And he says, if you're in the UK and you care about creatives and about creative industries, please write to your MP. So I'm going to say that if you have an MP and if you're part of my UK audience, please do that. Please write to your MP about this. And of course, we got some jackass in the comments. If you go to the library, you can read as many books as you like and learn from them. AI learns from books too. You can't copyright whole sections of books and publish them. Similarly, AI wouldn't be allowed to quote whole sections verbatim, and it doesn't. And he says right here, some argue that if generative AI companies are infringing on copyright, then so are humans who learn from others' work. This is not true, as confirmed by the US Copyright Office. The Copyright Office points out even humans are not allowed to do the kind of copying that AI companies do. The speed and scale of AI training is much greater, meaning it would be treated differently. AI training and human learning are different processes anyway. Saying, but humans learn this way is a very weak argument for unlicensed training, and it is inaccurate and portrays the misunderstandings of copyright law. So I'm hoping that because the US made this today, that maybe the UK can follow suit, and then maybe we can kind of get somewhere, because the video that I uploaded the other day, something's going to happen with that, I feel. And if we can just get in the same direction where everybody is like, okay, yeah, prompts and AI images can never be copyrighted. Yeah, you know what? If you want to do the lazy way out, you want to fuck around and you want to type stupid shit into a prompt machine and then get 900 images of the stuff that you goon to, okay, we'll do that. But none of that stuff's going to be copyrightable because you didn't really do anything. You didn't do anything. Like, I feel like if we could just be honest, I know that like, oh, it's a toy. It's someone else's toy. It's not even yours. So I don't know, because even though we have a win for today, we all know that tech will not stop there and people will keep trying to spam it until they get their way, or hopefully that maybe they'll never get their way. So my question to you guys is, okay, so on one hand, we have the US Supreme Court finally acknowledging that a machine isn't an author, but then you look across the pond and the UK government is literally trying to rewrite the rules to give AI companies a free pass. I feel like it's a tale of two realities, and I want to know I kind of want to know which one you guys think is going to win, because I feel like we're kind of witnessing the last stand for human creators, because this is why I feel like we can't just log off and ignore it. And if you're an artist in the UK or anywhere else, like, I do want to hear from you. I'm just kind of interested in what you guys see in this absolute mess. And if you're interested in my Patreon, please go over there and check it out. Also, please subscribe. I would love to hear from you guys, and I'll see you in the next one.